Assalamualaikum warahmatullahi wabarakatuh and salam sejahtera. My name is Haja Sakinah Binti Kamaluddin with metric number 255812. Today, I would like to present to you regarding the case of Lim Baba against Public Prosecutor 1962 1 MLJ 201. This case is related to the offence of abducting a woman for the purpose of illicit intercourse under Section 366 of Penal Code. This case was first brought in front of the President of the Sessions Court, where the appellant had been convicted for the offence. The case later had been brought appeal to higher court by the appellant. The fact in this case is that the appellant had abducted a 19-year-old woman with the intention to commit illicit intercourse with her. This was being carried out by the appellant together with his companion, where first they started attack complainant's partner, then put her in the car and drove away to another place in order to sexually assault her. After the sexual assault occurred to the complainant, the appellant had brought her to another place and left her there. The place where the complainant been left is near her partner's house. After being released, she immediately told her friend, who is a police inspector, regarding what happened to her. On their journey to the police station, both the complainant and her friend, who is the police inspector, came across appellant's car. The complainant pointed out the appellant and his companion to her friend. Her friend, without wasting time, took an instant action where he dropped the complainant at that place and went after both appellant and his companion. This fact was calm for the complainant's side. However, from the appellant's side, he firstly denied the charge. He defends that he was driving home at 11 p.m. on that day the event allegedly occurred. At that night, he met a person who is a man which he does not know very well. The man compelled him to go to a place which he complied the request. At that place that he went, he saw the complainant and an unknown man did a sexual action. He also stated that his companion is the one that assaulted the man, and after that compelled him to bring him together with companion to be dropped to another place. He stated that the companion went off first in a place, then after that his companion follows to be dropped in another place. The appellant was on his way to police station when he saw the complainant friend, who is the inspector police. After hearing both sides of story, the court had held in favor of the complainant. The judge who heard the case, which is the president of the session court, had convicted the appellant for the abduct offence under Section 366 of Penal Code, where he had been sentenced by the president of session court for 1.5 year imprisonment, together with fine amounting to $200. The case was later being appealed by the appellant, where the main issue for it being appealed is against the conviction and sentence. There are 4 issues being brought by the appellant in this appeal. One of the main issues that have been discussed in this case is regards to the learned president mistake in disallowing any questions by the appellant counsel as to the complainant's character. Pursuant to that, the judge during the appeal had an opinion that when the prosecution evidence lies entirely on the evidence by complainant, a cross-examination in regards to the character of complainant is relevant to be made. In this case, there is no clear reason for the action taken by the learned president in forbid all questions relating to the character of complainant. At the end of this appeal case, the learned judge had allowed the appeal and had for this case to be retried at session court in front of another president, due to the feel that the appellant defense had been prejudiced. From this case, there is several matters that I can learn. First is in regards to the character evidence of the complainant, where for the case that especially involve rape and attempted rape case, this evidence can be as admissible as one of the evidence. Generally, the evidence of complainant character is immaterial in criminal cases, which they have been stated in this case. However, in related to rape and attempted rape matters, this evidence become exception for this specific category of cases. The evidence is permitted in order to show that the complainant is generally immoral. Moreover, what I learned from this case is that the burden of proving the complainant character immoral lies on the appellant's side. In this case, due to the prosecution had relied mostly on complainant's evidence, the learned judge opined that the cross-examination related to complainant's character is relevant to be given by the appellant. This is made for the purpose to injure his character as stated under Section 146 of the Evidence Ordinance at that time, where the similar section had also been stated in Current Evidence Act 1950. Under this section, it stated that a witness may be cross-examined as to credit by injuring his character. Question could be put in relating to fact and issues or matters necessary to be known in order to determine whether or not the facts in issues existed. By making this, the credibility of complainant in giving the evidence can be seen. For the recommendation or suggestion for improvement, in my opinion, there are several things that can be improved in terms of the application of character evidence. The first suggestion is in terms of the provision itself. The provision for the character evidence in regards to the complainant had been stated in Section 146 of Evidence Act 1950, which for witness in general crime cases, and Section 146A for the same statute for the complainant in the case of rape. The position of this section is too far from the main position of character evidence, which in Section 51 of Evidence Act 1950. I suggest that the provision in regards to these matters should be arranged nearly in order to avoid confusion due to this provision had the same purpose which addressed the character's evidence itself. The second suggestion in regards to this is that due to the character evidence of the complainant is relevant to be admitted as evidence in rape case, there should be a proper guideline stated in the Evidence Act 1950 in regards to the scope of question that been relevant in order to establish her character. In conclusion, character evidence not only subject to accused, however, it may be subject to complainant, especially in rape cases. That's all from me. Thank you.